I'm thrilled to see everyone here. Welcome. I'm David Earle. I'm the Dean of the College of Arts, Social Science, and Humanities, and I'd like to welcome you all and thank you for attending this year's Seligman First Amendment Lecture. It's the 16th, actually more than the 16th year that we've been having this. And these lectures are funded by a generous gift from the Jane G. and Fred G. Seligman Endowment and sponsored by the John C. Pace Symposium Series, the Panhandle Tiger Bay Club, and the Askew Department of Government. I'd like to quickly relay the story behind the Seligman's gift in this series because the spirit behind it is important. And as we'll see, I think continues to be relevant and important today. So Fred Seligman was a Jewish emigre arriving in America from Nazi Germany in 1934. And as such, he cherished the freedoms protected by the First Amendment of the United States Constitution because of the restrictions on free speech that he had just experienced. And Fred Seligman understood the dilemmas that nations like the United States face in protecting these freedoms. The hope of the Seligman family, members of whom are here tonight, and I welcome and thank them graciously. The hope is that this series will foster a deeper discussion among the community, faculty, and students, particularly as the students prepare to lead in a world in which they may have to discern what is right and what is wrong. In the past, we've had speakers such as Art Spiegelman, whose work on the Holocaust was banned in schools and libraries in 2022, or last year's speaker Alex Berenson, who was banned from Twitter for his outspoken criticism of COVID vaccines. And I can't imagine two more different speakers from opposite sides of the political spectrum. Yet I think that both would agree about the need for free speech and the protection of the First Amendment. It's an issue that bridges the aisles, and this illustrates how both the lecture series and UWF offer a range of political positions in the interests of civil discourse and education. Our talk tonight is truly in the spirit of the Seligman lectures, and will offer some all-important context for both historic and contemporary censorship. If you don't know, there is currently a lawsuit for book banning against the Escambia County School District, which has drawn national attention. It's truly my pleasure tonight to introduce our speaker. Robert Spoo is the Leonard Milberg 1953 professor in Irish letters at Princeton University. Until recently, he was Chapman Distinguished Professor of Law and Professor of English at the University of Tulsa, where he edited and later co-edited the James Joyce Quarterly. He received his PhD in English from Princeton and his JD from the Yale Law School. After graduating from law school, he served as a judicial clerk to the Honorable Sonia Sotomayor when she was a member of the U.S. Court of Appeals of the Second Circuit. And Bob's return to Princeton less than a year ago as a homecoming for him. He spent 6 happy years there as a graduate student and a lecturer before moving to Tulsa to teach and write on James Joyce and other modernist and Irish authors. He couldn't have known in those years in his academic and intellectual life would eventually divide into two parts, literature and law. His turn to law began when, as an editor of the James Joyce Quarterly, he and other scholars were confronted with the active hostility of the estate of James Joyce and its copyright aggressions. New York Times wrote about an infamously litigious author's estate. Bob's research and teaching merged interdisciplinary interests in literature, law, free speech, and areas of intellectual property and public domain. His writing focuses on modern Irish figures, notably Joyce and Oscar Wilde, and he's actively involved in the law and literature movement within literature studies. Pairing his academic career with work as a practicing lawyer, he has assisted scholars, writers, and creative artists with the challenges of copyright and fair use, and served as co-counsel in the groundbreaking lawsuit to free scholars from unwarranted copyright threats by the estate of James Joyce. And he's incredibly generous with his knowledge, and he often helps graduate students and junior colleagues navigate the problems of copyright. I know that because as a graduate student at the University of Miami, working on my first book, I reached out to him, and he graciously helped me navigate the pretty scary copyright issues that one deals with, especially when one is unfamiliar with them. So in recent years, Bob's work has appeared in the Stanford Law Review, UCLA Law Review, Law and Literature, Cardozo Arts and Entertainment Law Journal, Journal of Modern Literature, James Lewis Quarterly, Journal of Modern History, and other venues. His book, Without Copyrights, Piracy, Publishing in the Public Domain, was published by Oxford University Press in 2013. In 2016, he was awarded the Guggenheim Foundation Fellowship in the Humanities, which supported his writing of Modernism in the Law, which was published in 2018 by Bloomsbury Academic. And he's just published a volume that he's co-edited with Simon Stern called The Elgar Concise Encyclopedia of Law and Literature, with 134 entries by recent and established scholars. In 2020 and 2021, he's held a Law and Public Affairs Fellowship at Princeton. He's also been an Oklahoma Center for Humanities Fellow at the University of Tulsa, where he explored the interrelationships among copyright, the commons, and freedom. So I would like you all to join me in thanking, in his first visit to Pensacola, Professor Robert Spoo.
Good time. Back. Listen.
Thank you, David. Am I audible? Am I on? All right. First of all, it's just an absolute pleasure to be visiting Pensacola for the first time that I've been here, and University of West Florida. And I'm absolutely grateful to the Seligman family, the founding family, for this talk, and for meeting Kay Seligman Valentino and Bill Valentino, I believe. Have I got that right? Very charming conversation earlier, and I look forward to talking to them again. And as I was watching Dean Earle's introduction, I noticed that there is a stoplight above me. And it seems to me that's a very appropriate prop for a talk about free speech, because right now we don't know whether that light is going to turn red or green. And I think that's it's hanging in the balance, isn't it, in some ways, for us, for our society, and locally, I think very powerfully for you. So I hope this talk will help us to put this into some historical context, and I'll spend some minutes, actually the beginning of the talk, talking about older censorship cases, obscenity law, before I move into, I hope, a somewhat helpful discussion about the current cases that are facing, some of the school cases, particularly the Escambia County case that I'll begin with. I don't pretend to have all the answers for this. What I do hope is that some of the discussion can inform us a little bit of what is going on with some of these lawsuits, where they are headed, and what the underlying theories, legal theories and legal stakes are for the cases. So let me begin and hope my clicker works. So as Dean Earle said, I have a chair at Princeton in Irish letters, so I teach Irish literature quite a bit. So I thought I might begin with a few remarks about Irish literature from the past. At a recent talk by an actor of the Abbey Theatre of Dublin, I was reminded of how that theatre, founded by W.B. Yeats, Lady Gregory, and others around 1900, struggled early on against censorship, large and small, by which I mean formal and informal forms of censorship. Yeats, Gregory, John Millington Synge, and other Abbey playwrights were bringing something new to the drama, depictions of Irish life that avoided, on the one hand, the laughing, weeping stage Irishman dear to English prejudice, and on the other, the pure, idealized Irishman and peasant that was cherished by many Irish nationalists. That's why Synge's famous play, most famous play, Playboy of the Western World, caused a riot at its premiere in 1907 when the chief character bragged about murdering his father and referred to Irish girls, quote, standing in their shifts, unquote, and also why his 1903 play, In the Shadow of the Glen, about a mistreated wife who takes to the road with a tramp was attacked by Irish nationalist leader Arthur Griffith as a slur on Irish womanhood. It's why Yeats's 1899 play, The Countess Kathleen, which shows a countess, a figure for Ireland itself, saving her peasant tenants from starvation by selling her soul to demon merchants, led to an outcry. A petition against its alleged irreligious anti-Irishness was signed by students at University College Dublin. One student, named James Joyce, loftily, proudly withheld his signature, resisted that requirement to conform. Lady Augusta Gregory, an Abbey Theatre founder, as I mentioned, left an account of the tactics used by informal censors to disrupt performances. They would sit in clusters at a targeted play, and at a critical point of the action would begin to boo, hoot, and blow tin trumpets. This fugue for tin horns was unleashed at a performance of Synge's Riders to the Sea, and Lady Gregory recalled it was impossible to hear a word of the play. The curtain came down for a minute, but I went round and told the actors to go on playing to the end, even if not a word could be heard. The disturbance lasted to the end of the evening, and not one word had been heard after the first 10 minutes. I think the important point of that story is they went on and they continued the play to the end, even though they could not be heard. Irish censorship also exerted pressure through local committees that would insist on reviewing plays and making changes before they were staged. Gregory was proud that the Abbey Theatre had not given in to what she called such organized dictation. After Ireland gained its independence from Britain, censorship continued, and it extended to books, particularly with the 1929 Censorship of Publications Act, and that allowed any citizen to complain to a government-appointed board about a book or publication. These are the procedures that we see happening today in various forms too. The permission, somebody can complain and trigger an entire process. Through the 1960s, banned authors in Ireland included Steinbeck, F. Scott Fitzgerald, Hemingway, John McGahern, Edna O'Brien, and Kate O'Brien, many others as well. The Irish novelist Colm Toibeen, you may have heard of, and incidentally, just as I speak here in Pensacola, Toibeen is speaking in Princeton tomorrow. So we're trading places. Toibeen has written that the urge to riot in a theater, to stop actors being heard, the urge to ban books, the urge to threaten to cut subsidy are almost built into our nature. They lurk always in the shadows, especially in societies where there are divisions and pressures and fears or sudden and uneasy change. Toibeen's diagnosis, to me, hovers between locating the urge to censor within ourselves and locating it in our times. Is censorship an internal need, or is it an external influence? Or does an internal readiness that is always there become active when social and political externalities are strained and fragile? Tonight, I'd like to begin with some of the earlier forms of censorship, mostly from the first part of the 20th century. And then, after a bit, turn to recent laws and actions that have been brought to bear in various parts of the United States on public schools and their libraries and on public libraries. This is a little bit apples and oranges, I admit. Censorship by federal or state governments and censorship by local school boards and parent groups are very different things in practical function and in legal significance. And we could easily trace school book banning, whether for conservative or progressive agendas, well back into the 20th century. But juxtaposing, putting together book bans from the 1920s, 30s with book bans operating in public schools today, I think will help us to understand why censorship in the school context is in some ways more complex, legally and socially, than the top-down censorship of earlier legislatures and prosecutors. Of course, some of that is still operating, and I'll talk about a bit of that as well. Traditionally, the nervous paradox at the heart of obscenity laws was that a crime that lacked identifiable victims was nonetheless believed strongly to inflict widespread social harm. It's hard to prove indecency's harm. You assert it and you assume it, more or less. Prosecutors in the 19th and early 20th centuries were not required to offer evidence that indecency had actually injured any individual persons, yet vice crusaders were passionate about stamping out this, and I quote, deadly poison cast into the fountain of purity, unquote. The nature of the poison was no easier to pinpoint than its claimed effects. Obscenity was a crime in search of a definition, an offense that was floating on a sea of indignant adjectives: lewd, lascivious, filthy, indecent, disgusting. Obscenity law grew to be a tool of opportunistic moralism. In the late 19th century, I'm trying to point when I'm trying to click. In the late 19th century, purity groups and prosecutors in Britain and the United States increasingly targeted literary and artistic works after decades of focusing chiefly on pornography of the grosser type. There's a turn. These cleansing campaigns came to include books that soberly discussed birth control, national poverty, and reproduction and population. Regulation became a weapon for attacking uncomfortable ideas as much as raw prurience. The sanctioning force of censorship reached to almost everyone and everything in literature's communications circuit: publishers, printers, booksellers, sales clerks, the book itself. Vice crusaders and circulating libraries, no less than government officials, played their part as private scourges of the purveyors of indecency, or alleged indecency. In America, the New England Watch and Ward Society was established in 1878. Early on, the society pursued, for example, Walt Whitman's Leaves of Grass, and by the 1920s and the 1930s, the list of banned books included works by Faulkner, Hemingway, and D.H. Lawrence. In 1873, Anthony Comstock founded the New York Society for the Suppression of Vice. The society received quasi-governmental status when the New York State Legislature, and this is something to think about, the legislature in New York granted the society's agents, an otherwise private group, the powers of search, seizure, and arrest, and they exercised these very vigorously. Through formal prosecutions and informal intimidations, the society worried publishers and booksellers and hired undercover agents to pose as smut purchasers. They would even write decoy letters and try to lure publishers and booksellers into the trap of getting arrested. Under Comstock's successor, John Saxton Sumner, the society sought to suppress the works of many controversial authors, including Joyce, Lawrence, Theodore Dreiser, Margaret Sanger, Oscar Wilde, and Frank Harris. The vice societies wielded something that the law typically denied to courts and prosecutors: the power of prior restraint. Very important term in our First Amendment law. Prior restraint, that is, restraint before the book is out, stopping it. It's like those folks shouting at the play, not allowing it to be heard. With their bullying prestige, the societies acted as pre-censors, persuading publishers and editors to submit material for approval before publication, again a little like that Ireland situation where the local committees required submission of plays before they could be performed, and they would cross things out. In 1927, the New York pirate pornographer Samuel Roth, I've written quite a bit on Sam Roth, made 2 pilgrimages to obtain the Smut Hounds, that is, the Vice Society's permission and approval for things in his newsstand magazines. In New York, he sought the Vice Society's approval of an excerpt from James Joyce's Ulysses to be reprinted in his Two Worlds Monthly. Sumner, the leader of that Vice Society in New York, granted the request for the excerpt from Joyce, but disapproved the inclusion, and this is actually a text, of Benjamin Franklin's advice on choosing a mistress. And Roth wanted to publish that in his magazine called Beau, B-E-A-U, Beau. In Boston, the Watch and Ward Society gave bewildered approval to Roth's Ulysses extract, which that official said was a Cubist odyssey that entirely is beyond my poor mental and imaginative powers. But that official frowned on an article defending the of Charlie Chaplin. Chaplin had just married a teenage girl. The Watch and Ward president proposed this trade. You can have Ulysses, but not Charlie Chaplin. And this was proposed, a kind of a horse trade with a kind of paternal kindliness, as if the official were protecting Roth's own morals rather than rendering a decree that threatened a free press. Early in the decades of the 20th century, forms of prior restraint operated powerfully in Britain. While the Lord Chamberlain there determined which plays would be licensed for the public stage, private circulating libraries like Moody's and W.H. Smith's effectively determined which books would reach large segments of the public. You have to know that in Britain at the time, books were very expensive to buy. If you wanted to buy a 3-volume novel, for example, it's pretty expensive, but you could borrow it from a circulating library. You'd pay a 6-month or a 12-month library fee to. You got books that way, but they controlled things. Offerings were pre-screened. Offerings for the libraries were pre-screened to omit titles that had received complaints from subscribers or had been reputed to be indecent, a process that the Irish author George Moore ridiculed as what he called circulating morals. In Britain, printers, now mind you, printers often played an outsized pre-censorial role by refusing to set books and print them until their authors agreed to omit material deemed libelous or immoral. James Joyce's early book of stories, Dubliners, which many of you I'm sure have read, or read some of the stories, remained unpublished for years while English printers, actually for 10 years practically, while English printers who were legally vulnerable for libel and obscenity, along with publishers, anguished over an accusatory realism that insisted on naming actual public houses, describing a woman's legs, and employing words like bloody. Think of that now. I mean, this is when you, if someone in the communications circuit is made legally vulnerable, it can stop the entire circuit. I found it useful to identify specific mechanisms that have implemented the laws of obscenity and to distinguish between mechanisms that operated, I'm going to use a little bit of legal terms here, that operated in personam, a Latin phrase meaning against the person, against individuals or business entities in personam, and those that acted in rem, that is, against inanimate things. Two approaches. That is, some laws and procedures targeted persons and businesses and produced, disseminated, or otherwise made offending content available. Others targeted the books, magazines, prints, and other race, R-E-S, things that embodied offending content. Two approaches: you attack the person or you attack the thing itself. The pursuit of books as corrupting things invited spectacles of public cleansing, not unlike popular images of federal agents smashing kegs of beer during the Prohibition. And that is what this image is meant to indicate to people who see that, this is what we are doing. We are purging, the world of these offending items. Now, in Britain, the most basic in personam against the person proceeding involved the common law misdemeanor of what was called publishing an obscene libel, punishable since the 18th century. A private individual or a vice society, or later a crown prosecutor, typically initiated prosecution, and the defendant publisher or bookseller could be tried by summary process or by a jury in a crown court. In 1888, the National Vigilance Association, one of those private vice societies in Britain, obtained an indictment for obscenity against Henry Vizetelly for publishing English translations of 3 novels by the French author Émile Zola. The common law acted in personam against the person when it convicted, fined, and imprisoned the aging Vizetelly, who died not long after he was released from prison. Now, that's an in personam approach. The most formidable in rem against the thing approach in Britain was under the Obscene Publications Act. It's very often called Lord Campbell's Act, enacted by Parliament in 1857 to permit what the common law's sensitivity for individual liberties made difficult: search, seizure, and destruction of books deemed obscene by authorities. They could go into houses even with this law and search around for books. The action taken against the first English edition of D.H. Lawrence's The Rainbow showed Lord Campbell's Act in operation. In November 1915, after hostile reviews of the book had alerted authorities, Lawrence's London publisher Methuen received a summons to appear before the Bow Street magistrate and capitulated. He offered no argument. He said, "I'm sorry, I apologize, we'll give it up." And in all, over 1,000 copies of the book were destroyed, and Methuen was taxed the costs of the proceeding. 13 years later, very famously, Lord Campbell's Act was invoked against The Well of Loneliness, Radcliffe Hall's sincere, unsensational novel about lesbian lives. I say unsensational, there were no indecent scenes or language in it. When Hall's English publisher was summoned to defend the book, Cape's attorneys persuaded 40 prominent men and women, including Virginia and Leonard Woolf, to be on hand to testify to the novel's sincerity and its importance. The magistrate, and this is very typical for the day, refused to allow any witnesses, any expert witnesses at all. And after an adjournment to go back in chambers and reread the novel, or parts of it, he ruled that it had a tendency to corrupt susceptible readers, and he ordered all copies to be destroyed and assessed the costs against Cape. In a draft of A Room of One's Own, Woolf's famous discussion of professional female writers, Virginia Woolf vividly, this is in a draft, it was never published, depicted the in rem against the thing prosecution of an imaginary novel containing, like Hall's novel, references to lesbianism. And here's what Woolf wrote in that draft piece. "There flashed into my mind the inevitable policeman, the summons, the order to attend court, the dreary waiting, the magistrate coming in with a little bow, the glass of water, the counsel for the prosecution, for the defense, the verdict. This book is obscene, and flames rising, perhaps on Tower Hill, as they consumed masses of paper." Woolf's fearful fantasia precisely tracks all the elements of Lord Campbell's act. With grim playfulness, she figures the in rem destruction of books as an in personam execution on Tower Hill, the place in London where public beheadings of traitors and criminals of rank were traditionally carried out. So she saw this thing against the book becoming actually something against persons, a kind of execution. While the British attacked the Well of Loneliness in an in rem action, American authorities took an in personam approach to this book. The New York Penal Code made it a misdemeanor to sell or possess with intent to sell, and here are the typical language of the statute at the time, any obscene, lewd, lascivious, filthy, indecent, or disgusting book. After the publisher, Donald Freed, defiantly sold a copy of Hall's book to an agent of the New York Vice Society, the society returned with police officers and seized more than 800 copies. When Freed's case came to trial in 1929, Judge Hyman Bushell conceded that the Well of Loneliness showed, as he put it, restraint and literary merit, but still found its theme to be antisocial, again, these are his words, antisocial and offensive to public morals and decency, and bound Freed over for trial. Judge Bushell condemned the novel for its unsettling subject matter, not for any indecent language or incident. There were none. 3 judges in the higher court of special sessions, though, saw things differently and dismissed the complaint. And note that Judge Bushell condemned this novel, The Well of Loneliness, for the theme or the idea of same-sex love. I think that's very important, and a distinction important for right now, our moment, whether we are actually condemning things because of truly, indecent content, or whether it's an idea about such things. I'll return to that. The federal postal statute, notice I'm kind of going through some of the mechanisms. The federal postal statute that criminalized the mailing of obscene matter, Section 211 of the U.S. Criminal Code, was originally enacted by Congress in 1873 as a result of Anthony Comstock's tireless lobbying. The Comstock Act, as it was called, prohibited obscene books and other materials. Ezra Pound, the American poet, assailed the act as he put it, lumping literature and instruments for abortion into one clause, because it's true, what was banned in the mails was both instruments that would encourage abortion and books that talked about it side by side. It permitted materials to be seized as non-mailable matter and imposed fines for this. The Comstock Act's in rem against the thing provision permitted broad prior restraints. Things could simply be held up in the post office and not mailed at all. And it was very hard, incidentally, to overturn a postmaster's decision. Very hard indeed, and this proved to be the case when some of these were challenged in federal court. And the judge said, there's really nothing I can do about it unless I show that the postmaster exercised an absolutely abusive discretion, discretion in doing this. It's very hard to overturn it. One last in rem technique that had a significant impact on modern literature was the obscenity provision of the U.S. Tariff Act. In the late 1920s, the lawyer Morris Ernst, he's really modernism's great lawyer, worked to reform the arbitrariness of censorship laws as they were used by customs officials. And he successfully got the Tariff Act amended to allow for a more due process, essentially, for challenging a seizure of a book by a customs officer. The Tariff Act was lawsuits. What would happen is the U.S. attorney would then be required, if they were going to retain the book, to bring a civil action against the book, a forfeiture action, actually against the book, or whatever offending article. So examples of this during the Prohibition period, I pulled some of these titles from the archives of these cases, because I was looking for the Ulysses case, which was called United States versus one book called Ulysses, but surrounding it were all of these cases: United States versus one Ford truck, United States versus approximately 126 assorted glasses, a quantity of intoxicating liquors, etc., found at Club La Lune. These were just a couple of the many actions brought against property involved in illegal alcohol trafficking. This is prohibition, after all. In the spirit of protecting American purity, the U.S. Attorney filed forfeiture actions against Marie Stopes' book, Married Love, and her book, Contraception, books that discuss seriously birth control, adult sexuality, and married equality. But the Tariff Act customs case that had the broadest implications was the Joyce case, and I'll return to that briefly in a moment. The test for obscenity that came to figure prominently in British and American law was formulated in the 1868 case of Regina the Queen versus Hicklin, Hicklin, Hicklin. And that test was, quote, whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort might fall. This is a broad and elastic standard that could be really twisted in many shapes to find a book to be obscene. And a court could find that just a couple of phrases in a book were obscene, and the whole book would be condemned, irrespective of its entire context. And so, or the judge could do what Judge Bushell did in the Well of Loneliness case and find that the theme of the book was offensive. Even if defense counsel was allowed to read the uncharged remainder of the book into evidence before a jury, remember, you have to perform in front of a jury in order to get their attention. And juries often get very bored by long readings, and if they get bored, they take it out on your client. So this was something that was dangerous to do. So finally, just a couple of remarks about the Ulysses. Hicklin protected, the Hicklin standard protected what the lawyer Morris Ernst called the dullest witted and most fallible in our community. And in theory, it said that, that if one libidinous man existed in an Anglo-Saxon community, that's his phrase, then all its members would have to submit themselves to the inhibitions of the censorship. Paternalistic, overbroad, often invoked to protect the young, Hicklin might be called, and I've called it, the law of the child. It was focused to protect children, more or less. Jane Heap, co-editor of the Little Review, complained that American obscenity law permitted, as she put it, the mind of the young girl to rule the country. If there is anything I really fear, she wrote, pretty controversially, it is the mind of the young girl. The Hicklin test had a devastating impact on adult readership. So finally, that Ulysses Customs case in 1934, a federal appellate court upheld the trial court's conclusion that Ulysses was not obscene under the U.S. Tariff Act and could be admitted through customs into the United States. The ruling did a great deal to make more flexible and stabilize the standards for judging obscenity in the United States and indirectly and later in Britain. Up to that time, judges and lawyers were often groping for a coherent vocabulary with which to fix the meaning of the obscene. The Ulysses opinions helped clarify and standardize concepts such as the average reader, that there could be expert witness testimony admitted in such cases, and that the whole book had to be read, not just the portions that seemed offensive to a prosecutor. These ingredients would later be merged and fused and constitutionalized by the U.S. Supreme Court, particularly in a case called Roth v. United States. And yes, that's our friend Samuel Roth again, now 20 or 30 years later, and now a criminal defendant in an obscenity case. He lost at the Supreme Court level, but the Supreme Court established an important definition of obscenity that partly reflected the Ulysses ingredients. And most of all, and most importantly, the element of the First Amendment, the principle of free speech, is what really distinguished Roth from earlier cases. It's not that lawyers had never argued the constitutional question in obscenity cases before, but judges had resisted. It was considered then a novelty that they weren't willing to entertain. What were they looking at? You had to argue that the book was, you had to weigh the obscenity against the good passages and things. It was a fact question as opposed to really being a legal question of the First Amendment. After Roth and similar cases, judges could stop doing that weighing and quantifying of obscenity, and they could decide that question under the First Amendment. Courts could now do what even socially progressive jurists of earlier decades could not: openly concede a book's offensiveness, yet rule that inherent free speech values forbade suppression. Under Roth and later cases, regional moralism was giving way to a nationwide standard, a unified constitutional test of social value instead of the patchwork of laws from one state to another state across jurisdictions that often made a victory in one court just a prelude to litigation in another. I'd like to turn now to the present moment, and from state and federal book banning to the censorship activities of local school boards and other concerned groups. This may be what's very much on some of your minds. State legislatures have been very active in recent years, as you no doubt know. In 2023 alone, and this is just a few state laws have been adopted to protect minors from online distribution of harmful materials in schools, libraries, and elsewhere. That's Arkansas, Louisiana, Mississippi, Oklahoma, elsewhere. Laws to define the word sex and create requirements relating to titles and pronouns in early sex and reproductive health education right here and other states. To prohibit schools from teaching about gender identity and sexual orientation in K through 6, and to impose requirements on school library programs and materials. To allow requests from parents and others to remove materials deemed obscene or harmful from school libraries. To cause materials purportedly harmful to minors to be confined to restricted areas in libraries or bookstores by request of parents or others. Come back to these, some of these. And to limit and regulate the sale to school libraries of materials deemed sexually explicit or sexually relevant. That's a Texas law. Now, many of these laws enshrine parental choice as fundamental and confer on parents powers to monitor, select, restrict, or remove materials in school and public libraries. As early as 1925, the U.S. Supreme Court in Pierce v. Society of Sisters recognized a fundamental constitutional liberty of parents and guardians to direct the upbringing and education of children under their control, the court famously stating, the child is not the mere creature of the state. In other words, parents should have a fundamental liberty in helping to shape the educational destiny of their children. Not controversially in a way, it's been around for 100 years at least. But the present statutory expansion of the parental role is what I've noticed in public education. This seems to me to risk casting doubt, particularly on the traditional competency and authority of teachers and librarians, perhaps eroding the distinction between public schooling and homeschooling. We allow the parental voice to get too insistent. Do we still have public education, or do we have something else that is simply more or less being directed from the home? What we also see in these laws is a fast-tracked process for lodging complaints against books that sometimes appears to create a presumption in favor of the complainant. a structure resembling that Irish censorship board I mentioned earlier, which permitted citizens to complain to this government-appointed board about any book deemed offensive, and there would be sort of quick action taken. Well, this probably is familiar. Penn American Center lawsuit. Recent state laws have been challenged in courts. This is one. A federal lawsuit familiar to many of you will be Penn American Center versus Escambia County School District and Board, in which a group of authors, publishers, and parents with students sued over decisions to remove and restrict books from public school libraries as part of an effort, as the complaint alleges, that disproportionately targets, this is the language of the complaint, disproportionately targets books by or about people of color and or LGBTQ people, and prescribes, again, language of the complaint, an orthodoxy of opinion that violates the First and 14th Amendments. Although school policies require typically a multi-level review process for challenges to books, the complaint here alleges that the district instituted a procedure by which, quote, any challenged book would automatically be subject to restricted access during the review process. So again, the presumption was in favor of removing the book even before the review process had fully occurred, according to the complaint. Short-circuited review, ease of challenge, censorship based on, language of the complaint, political or ideological disagreement with the ideas. All these are alleged in the lawsuit that claims that the litigation has gotten it to about 130 books, including one you may know called And Tango Makes Three, a 2005 picture book based on an apparently true story of two male penguins in a New York zoo that bonded and raised a baby penguin, were removed or restricted because they were thought to promote same-sex relationships or other agendas. The Penn American Center lawsuit advances, the challenge here advances two basic legal theories. The first of these is that these removals and restrictions violate the First Amendment because they are based on disagreement over ideas and messages rather than what the complaint calls pedagogical reasons, creating what the law calls, First Amendment law calls, viewpoint discrimination. It's an especially sensitive area of First Amendment law because viewpoint is something that we value very, very highly in our society, so that if viewpoint discrimination has occurred, a First Amendment violation is almost certain to be found. The lawsuit also alleges a violation of the student's First Amendment right to receive information and ideas. There is a right to receive information, simply because school officials disagreed with the ideas. Finally, and most creatively, the plaintiffs allege that in removing books disproportionately, this is the language of the complaint, authored by non-white and or LGBTQ authors, school officials have violated the Equal Protection Clause of the 14th Amendment by discriminating on the basis of race, gender, or sexual orientation. The court, now there was a motion to dismiss. One of the most recent things to happen in the case, there was a motion to dismiss by the school defendants. And the court denied most of that motion to dismiss early last year, allowing the plaintiff's First Amendment claims to go forward, but it did dismiss the equal protection theory. The court found that the equal protection claim, and this is the language of the court now in its order, amalgamated non-whites and LGBTQ individuals, even though they are discrete protected classes, and required far too many inferences about intentional discrimination in the case. Now, equal protection is about targeting a class of persons, a protected class, typically race or gender, for unequal treatment and the court did not believe the complaint made out a clear allegation for that. And that was dismissed. I should note that equal protection claims are very difficult often to make stick. You have to show a lot of things. The case has been temporarily stayed pending appeal of an order authorizing depositions of school board members. Incidentally, there's a big dispute over whether school board members are protected by an immunity from being deposed in a litigation. This is a big issue right now in the case. It may be significant because one of the things you might have to show some intention, and it would be good to get this testimony. Certainly good for the plaintiffs. So what is the controlling law concerning the discretion of public school officials as applied to the Penn American Center case or similar cases? In contrast to First Amendment law applied to top-down bans by state and federal governments, which I've just been discussing from the earlier period, the law in school contexts is less developed and less clear. This should not be surprising. It's one thing if a prosecutor, postmaster, customs official bans a book like Ulysses or Lady Chatterley's Lover. But quite another thing when a local school board or parent-teacher group decides that a book is inappropriate for school children. In other words, the law respects local feelings and views and sensitivities. Our law understandably shows deference to that and to decisions that are made in loco parentis, in Latin, in the place of the parent where minors are concerned. The Supreme Court case most directly addressing these issues is one called Board of Education versus Pico. It's from 1982, pretty old case by now, where a plurality of justices ruled on a challenge to the removal of books from public school libraries that were purportedly, and this is the language of the removers of the book, anti-American, anti-Christian, anti-Semitic, and just plain filthy. The plurality opinion, which was authored by Justice William Brennan, was careful to point out that the court was not being asked to intrude into the classroom or into the compulsory courses taught there. In other words, this was not about what was, in the curriculum. Instead, this was about removal of library books that are optional for students rather than required, that were originally originally purchased by the school itself. They were then removing. Justice Brennan's opinion walked on eggshells, acknowledging the broad discretion of local boards in the management of school affairs. That discretion includes, in many cases, the educational suitability of books, vulgarity, pornography, and indecency. These are things that local school boards can have a role in. But Justice Brennan held that school boards, this is his language now, may not remove books from school library shelves simply because they dislike the ideas contained in the books and want, his words again, to prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, unquote. There is an intent requirement here. To violate free speech, school officials must have intended to deny access to ideas with which they disagreed. And that's one of the reasons that it may be critical that school officials may not be deposed in the case, because their testimony may tell something about the intention of the school board and the school officials acting. This holding of Pico recognized a First Amendment right to receive ideas that follows from the sender's First Amendment right to send them. There's a sending right and a receiving right in our First Amendment. Students, the court said, may not be regarded as closed-circuit recipients of that which the state chooses to communicate. So we're in the age of closed-circuit TV that this was decided. Applied to some of the school board activities currently being challenged, the Pico plurality's holding would seem on its face to forbid removing a book from a school library because a parent or official felt that the book served a woke agenda or promoted an alternative lifestyle, gender identity, or domestic arrangement. This would be what Pico calls an intentional effort to ban ideas and opinions that don't fit a prescribed orthodoxy. But there's no guarantee that legal challenges to these school board practices and the state laws that enable them will succeed. First, school officials might try to characterize their disapproval of ideas as disapproval of indecency, vulgarity, or unsuitability of books, a choice that Pico and other cases acknowledge as within the discretion of school boards. Of course, even here, there are limits to bans that openly flout the Supreme Court's obscenity rule. But again, school boards operating in loco parentis, the place of parents, have greater freedom to protect minors than legislators or prosecutors imposing broad-based top-down bans on all readers. Second, the most cited Supreme Court case in this area, the one I've just mentioned, Pico, is, as I've said, a plurality opinion. That's an opinion that did not receive the support of a majority of the justices, but still received more support than any other opinion, except for dissenting justices. In other words, at least 5 of the justices agreed on the result, but less than 5 agreed on the reasons for the result. Plurality opinion. Still good law, but it's weaker law because it's easier to distinguish, it's easier to challenge, and if it comes up to the Supreme Court for them to decide whether they're going to change the law by reversing their Pico decision of 1982, it's easier to reverse because they can say, we never did have a full agreement as to the reasons here. So, let's move on to a couple of other recent cases that are at issue. Book people rather. I want to mention these. The first there is the law that requires school book vendors, that is sellers of books to schools, who wish to do business with the public schools to issue ratings for all library materials they have sold or will sell, tagging them as either sexually explicit or sexually relevant if they discuss sex in any way. In Book People versus Wong, a group of booksellers, publishers, and authors has sued Texas state officials for enforcing such a law, alleging that it grants the state illegitimate licensing authority to decide which books may be available in public schools, that the law violates the free speech rights of booksellers by compelling them against their will to state that a book is sexually explicit or sexually relevant based on the government standards, not their own. This is what we call a First Amendment violation for compelled speech. If the government makes you say something that you don't want to say as an official requirement, that could be a compelled speech problem. Also, a challenge is to the vagueness of the law and its terms. A vague law can result in a constitutional violation of due process, because with due process, we're supposed to know in advance whether we're violating the law or not as a matter of notice. And if we can't, if the law is too vague, our due process rights might be violated. So, a federal trial court issued an order preliminarily enjoining this law and in the Texas area, and in January 2024, a U.S. Court of Appeals affirmed that order, holding that the plaintiffs were likely to succeed on their compelled speech claim. The claim goes forward in this case. My review of earlier censorship showed that when proponents of bans enlist libraries and booksellers, willing or not, to bottleneck books, the battle for censorship is almost won. This was the in rem effect that stopped books at their source rather than punishing the reader. You don't need to punish the reader if the book never reaches the reader. Another type of state law currently being challenged is one that imposes criminal liability on those who make available to a minor any material deemed harmful to minors. This law, it's feared, will force libraries and booksellers to create restricted areas for adults only, or for older minors only. Less than 3 months ago, an Arkansas federal court granted summary judgment to plaintiff librarians and booksellers, holding that the law gave them no choice but to segregate potentially hundreds of books from disposable, this is the language of the court order, from disposable paperback romance novels to classics of literature like Romeo and Juliet, Ulysses, Catcher in the Rye, The Handmaid's Tale, or The Kite Runner. In other words, to avoid criminal penalties, again, the court goes on, librarians and booksellers must impose restrictions on older minors and adults' access to vast amounts of reading material. This is a classic example, incidentally, of what the First Amendment doctrine calls an overbroad law. Overbreadth is a doctrine. One likely to create unnecessary free speech casualties in its war against purported indecency. Sweeps too broadly. The court also found the language of in this case, the Arkansas statute, too vague, again threatening due process rights. In general, the court held that the law would this is the language, all but guarantee that the books would be removed or restricted based on their communicative content or viewpoint, and was not narrowly tailored to serve a compelling state interest. The court entered summary judgment there for the plaintiffs. That will undoubtedly be appealed, I suppose, but the court so ruled there in Arkansas. Here then, to sum up, are some of my concerns as someone who is a supporter both of free speech and of public schools. In a time when the important vocation of public school teaching is under stress from low salaries and low morale, what message is being sent by sharply restricting the autonomy of school teachers and librarians? In further elevating the role of parents, not to be sneezed at, it's an important role, are these laws diminishing the role of teachers and librarians and making public schools look more like homeschooling, which is also an option, for parents? When overbroad laws seek to protect younger minors at the expense of older minors and adults, are they enacting some version of that law of the child that I mentioned earlier that caused many authors and publishers in the previous century to worry that a standard enshrining the especially fragile, vulnerable person would come to govern choices made for everyone? Are these laws returning in the school context to the cherry-picking of indecency that the Hickman standard permitted, where a prosecutor could point to a few controversial words or phrases in a 300-page book and ignore the rest? Are we willing to see repeated what Judge Bushell did in the Well of Loneliness case nearly 100 years ago now, when he condemned a book that he admitted showed restraint and literary merit because its theme of alternative sexuality was thought to be antisocial and offensive? Lawyers fought hard for decades to unify the national patchwork of inconsistent obscenity standards by ensuring that books containing serious literary, artistic, political, or scientific value would not be condemned just because they contained some controversial or offensive passages. Will piecemeal school laws and bans in different states return us to the checkerboard of standards that a century ago eroded learning and degraded literary achievement? Thank you.
We do have time for questions. I believe there are going to be some microphones walking around if you have questions. And then I'll make a couple comments at the very end. And questions? Anyone? Great, thank you. Okay, I mean, I'm sure there are questions. I see hands starting to come up, so please. This question right here in the middle is
All you asked in the growing this like digital world, how you think that vocation at the end and like the near future?
In an increasingly visual world, also a world in which the internet offers on a minute-by-minute basis, more potential harm, really, than the schools could do in years. Yeah, I think it is. I think it is a huge issue. Of course, there are efforts to curb internet use within the schools, and there actually may be some good basis for that. I mean, there may be things that kids should not be accessing on school premises. But yeah, I think the issue of the visual and the impact of the visual and the availability of the visual. After all, don't we say that a picture is worth 1,000 words? It may also be worth 1,000 harms. Yes, I see that. I see that issue.
What advice would you give for anyone here in higher education who's now facing issues of censorship or self-censorship?
Listen to your dean.
There you go. There you go. I mean, listen to your dean and listen to the courts. I think the courts are moving on this. Look at, in some ways, how rapidly these three big cases that I mentioned have moved along. And now, mind you, each of these cases is right now tilting towards the plaintiff's position. I don't say they ultimately will, but they are tilting towards the plaintiff's position in Florida, in Texas, and in Arkansas. Those are the three cases, and those are fairly conservative courts and also conservative appeals courts. And what is emerging is a tilt towards at least the First Amendment claims of the plaintiffs. Now, a lot of this I think this is probably going to come up to the Supreme Court, and we're going to find out where they stand and what they do with PICO. PICO is that case, I think, that is a little bit wobbly because of its plurality status. So, yeah, I think what practical advice? I don't know if there is practical advice. Sometimes the practical unfortunately yields to the legal. Isn't it scary that we have our lives in the hands of lawyers? I mean, it's certainly not my idea of a good time, but right now we do, and this has happened before, and lawyers do step up for this, and courts do too. I think we should have one thing. I think we should have, if we can't do anything immediately, that at least the dean doesn't authorize for you and just watch his words and memos. But I do think we should have faith in our court system. I know it's sometimes a little bit hard. It has been stressful for me in a number of ways to see some of the trending. But I think we should have faith in our state and federal court systems that they will uphold free speech rights, both in and out of schools.
Professor, where do you come down on the issue of public elected officials, school board members, not having to be deposed?
I'll tell you the truth. I have not read the full briefing on that issue. I know that what has been invoked and has had some success at the lower level is an immunity, a sort of a legislative immunity that says that, because we know, for example, that legislators in the federal legislature are immune for anything they say or do within Congress. That's a constitutional mandate. And so by a sort of derivation, that has been brought to the state levels and now extended to these school officials. I think one of the questions is whether they truly are functioning in a legislative capacity. I'm not sure I buy that argument fully. I also worry that the lack of depositions, you may have noticed that one of the things you have to show in a PICO challenge, you have to show intent by the school officials to suppress ideas. You have to show intent. And intent can be shown lots of different ways, but one of the ways is through obtaining testimony from the alleged suppressors. Without that, intent will have to be shown circumstantially. And it might well be showable. We show a lot of things circumstantially. People are convicted of murder circumstantially. But I think it does make things a little bit more difficult. I'm not crazy about the ruling. I will say, though, I must be a little modest to the extent that I have not read all the briefing and come to a full view of it. Great question.
I would like to say thank you for coming out first.
Yes, okay.
Thank you for coming out and giving such a good speech.
Thank you.
So my question deals with the parents' choice to be able to pick and choose what can be allowed in tax-funded education or in the libraries.
Yes.
Could you define more on what you consider censorship and what you consider a book ban? Because I followed this, the DeSantis, whenever he and the administration decided to pull books from it.
Right.
And in nowhere does the literature say that the state of Florida will ban it from Amazon or from book publishers or anything like that for the public, general public to be able to get a hold of.
Yeah, right.
Where do you draw that line?
Okay, thanks. So in other words, one of the views here is that, okay, it's going to be removed from the libraries, but school libraries, but it will be available in all kinds of other ways, and shouldn't the parents, have that role? And I hope in the remarks I made that I show deference to parental sensitivities. I think parents should play a role here. But let's see exactly what is being challenged in the Penn American Center case, or what's not being challenged. Here's what's not being challenged, and really can't be very easily challenged. The mandatory curriculum that is set by school administrators, by school boards, and by parents that are engaged in parent-teacher groups and consultations. The courts cannot get involved in, or they have not gotten involved. They said we don't get involved in the mandatory school curriculum. Nor could the courts possibly force a school to acquire books it does not have. So you can't say your library doesn't have Ulysses, you must buy it. That cannot happen. The thing that's being challenged here is the removal of books that were once placed there by the school itself, now being removed there. And partly that issue is about the student's ability to have some option to choose as opposed to the curriculum itself. I don't know if you're like me, folks in the audience, and remember a time when you got free of a class in high school or in grade school and you wandered into the library. How many of you actually have memories of wandering around in the stacks and, encountering a book that was just fascinating to you? Oh, I remember reading Eugene O'Neill, of course, one of the challenged authors, Desire Under the Elms, things like that. I remember, or J.D. Salinger, things like that. Wandering into the library and encountering these. That is that journey that is optional and that is a freedom of creative and curious choice. What is mandatory in the classroom is very different from what is found on that odyssey within the library that is not required. And that is the thing that is the point of sensitivity in the PICO type of case, which Penn American Center is. So that's how I would respond to that. Thank you.
Yeah, looking at a little broader view, given the current litigation and past litigation, what do you think the possibilities of public libraries being restricted to adults only?
I think there is a movement in that regard. Some of these challenges do involve state laws that allow some of the similar removals and restrictions to go to public libraries as well as school public school libraries. So there are parallels, and I do think some of these laws are going there, and some of these challenges will have to go there as well. Absolutely. And not only restricted to adults only, possibly even begin to remove books that seem inappropriate there too. So for anybody. So yeah, I think that's a real question. And one of the problems with this restricted book approach, and this is bookstores and libraries, is that if you create this cordoned off space where the mature books are, as opposed to these spaces where the younger people can wander and choose, you're stigmatizing this space. So somebody who wants to go and check out a book from the restricted space must go over to a counter, and a counter that is designated as mature only or sensitive only, and then request that book. A lot of people will be chilled by that. That's the old tactic of the under-the-counter approach in bookstores that sold the dirty books under the counter. You had to request it. Could I check out could I buy Lady Chatterley's Lover? Do you have it under the counter? Well, that's a chilling effect. And I think that's one of the problems in any kind of library, but it endangers both school and public libraries, most definitely. Yes.
Could you speak about the intersection of parental? Can you speak about the intersection of parental intent and school board intent in that PICO standard? Because I can imagine a school board saying, we don't choose to restrict anything based on ideology. We only want to do whatever the parents.
Right. I don't know that the cases make that distinction, but I think that if the school board wanted to shift the intentionality to the parents and disclaim it for themselves, I think the logical result would be to say, well, it may be what you deem to be the parent's choice, but you have adopted it as your intent. I think that's probably, and in fact, I think that's one of the things that probably the defendants would not want to say necessarily in cases like this, because they might be conceding an adopted intent. At least I would think so. Yes?
I remember when young people in middle school age had to get permission from home to go to sex class.
Yes.
And I'm wondering, any school districts I'm wondering if any school districts have thought about just eliminating all of this. And I am almost an absolutist when it comes to free speech, but and just getting permission slips from parents about what they do or don't want their children to be.
Right.
I mean, I don't know how it would. It's just a thought.
No, I think it's. I don't.
Be implemented. I'm not sure.
Yeah. No. It's a real concern, and there are laws that are recently been enacted in states that do really diminish the types of sex education that can be delivered, particularly K through 6.
Well, but I was talking about. I was just using that as an analogy.
Okay.
I was talking about the books in censorship.
So you're saying that, well, we eventually have to bring permission slips or something to...
My child to go into the library and whatever.
I don't know of any law that is, or school board decision that is structured exactly that way, but I think it's not impossible at all. Again, this idea of centralizing the role of the parent, and this is, again, not something that we want to diminish, but I think it's not something we want to make too big. Because after all, even the subject of sex education, this is partly, as so many things in America right now, a question of norms that are under assault. It's not just laws, it's not just specific entitlements that can be defended in a courtroom. It's partly our norms. What is the norm by which we trust teachers that have trained and sacrificed their lives, and many of them sacrifice salaries in order to do this, and we don't trust them to teach things to our students. And that's why I suggest this. I don't think it's just a cartoon or dystopian view. that public schooling might become much more homeschooling if parents become that larger role. And why do you have a public teacher at all if we don't trust their judgment and their knowledge?
So I was wondering if you could speak to whether or not you think there's some common ground or a shared possible root cause between the restriction of speech from intellectual property and copyright laws and the kind of censorship we see here. And I mean that both legally and sort of like theoretically or ideologically.
Wow, what a great question. It so happens I've written on that subject. And I'm very fascinated by the way copyright and obscenity law do some of the same odd things together. Obviously, a copyright law enables a copyright holder to control uses of that work, to be able to suppress the work even if they want to. If they don't want anybody to publish it, they can suppress it and they can sue anybody who does for copyright infringement. Right? Well, fair enough. Our laws permit that. I was involved, and I talked to some of the students today in Professor Lee Gall's class about a misuse of copyright, which in some cases has occurred. I was actually involved in a lawsuit against the James Joyce estate that was doing this, and that was using copyrights to essentially to suppress speech. Instead of simply trying to obtain economic benefits as copyright is intended to do, they were trying to use it to silence critics, scholars, those who wanted to delve into James Joyce's life. In other words, they were using it as a kind of what they claimed to be a privacy. There is no privacy in the United States, a privacy right for the dead. You can't defame a dead person, really. You can't invade their privacy rights. So if you're using copyright to affect that privacy right, you're misusing the copyright. And we shouldn't be allowed to use a law that is proper for an improper purpose. That is one way in which copyright law, I think, can begin to look like an obscenity, a law that suppresses a censorship law. And I think I've often thought that censorship laws are kind of super copyright laws, in the sense that it allows not an author, but a government to control speech, and is so powerful as that control that they even control the author's speech. So it's like a super copyright. But anyway, it's a great question, and there, I think, are a lot of parallels. If we misuse copyrights, we start to suppress speech in ugly ways.
We have time for one more question. Someone wants to finish? All right. Thanks. Well, so first of all, I'd like to thank our speaker, Dr. Spoo.
Thank you.
And of course, I'd like to thank the Valentino and Seligman family so very much for helping us continue on what I see as an incredibly important series of lectures here. You got to wait for the speaker so they'll give you feedback. And of course, the dean staff and historic trust staff have done a wonderful job as always, and they're probably thanked too seldomly. So I want to make sure to thank them, the Department of Government as well, for helping and supporting this. So we have a few more events coming up. Let me get the dates right. So we have the Ask You lecture on March 27th, which is Debating American Grand Strategy. And if you're not familiar with the snow week that we had and had to cancel the John T. Edge event, if you know about True South, he's going to be here on April 15th. And we moved locations. It's going to be in the Pensacola Little Theater. And that is also going to launch our Gulf Coast Culture Series. Now, all of these events are free. They're open to the public. If anybody would like to donate to help us continue this on, that would be fantastic, to the College of Arts, Social Science, and Humanities. And besides that, I want to thank everyone. We have time to mingle and converse. I'm sure there might still be food unless they took it away. But towards those lines, everybody, please, thanks again, and I'd love to continue the conversation. So, thank you.